Okay. Chrissy, are you ready?
Good morning, I'm ready.
Good morning. Good morning, everyone. My name is Harris Adams. I'm the administrative law judge assigned to hear proceeding number 23A-0598R. This matter comes on for a pre-hearing conference pursuant to decision R24-0206-I. I'll call the pre-hearing conference to order if we can start with entries of appearance.
Craig Carson, Your Honor, here from the AG's office on behalf of CDOT.
And
Good
Stephanie
morning.
Montague on behalf of BNSF.
Good morning. After some informal communications with the parties, seems like we're not on a procedural track yet. So I wanted to check in with the parties, get on the record a little bit and see where we're at in the case. I'll note and appreciate that CDOT did waive the applicable statutory period governing the timeline for issuance of a decision. So I'm not pushing because of a need to satisfy a statutory deadline. But I wanted to check in with the parties and see where you're at. So, Mr. Carson, it's your application. Are you ready to get a procedural schedule going, or is there something else going on that might benefit where we're at?
No, I think we've met informally with BNSF, and we weren't able to come to an agreement that was satisfactory to both parties. And so I think we're ready to go ahead and get started with the schedule.
Okay. The application was filed without testimony. So the first step would be to have that direct filed testimony. Oh, before I do that, and I mentioned this in my informal email, Mr. Carson, you've requested either a remote or hybrid hearing, and I'm more than fine with that, and have to accommodate that. So the procedures I'll adopt will be in contemplation and planning for those electronic exhibits to be available and used for hearing. So that you know that. And Ms. Montague, I understand it's your inclination that you or your client may want to attend in person. And is that still the case?
I have at least a witness here. I may have, but I mean, we have the ability to do hybrid procedures as well. I'm not, I don't know because we don't have a date. I can't say where everyone's going to be, but we can work with whatever is occurring. My preference in a hearing scenario is that it would be in person, but we can be flexible about it.
Okay. Well, we'll come back to that maybe at the end of this conversation and see where you are. Okay, then back to you, Mr. Carson. I think the next step is to get some testimony filed. Is it the party's intention? Well, is it the party's intention next, I guess, to do pre-filed testimony or live testimony?
I thought we'd do live, but I'm open to whatever the court would prefer.
Okay, because to do the hybrid, we would have to have pre-filed exhibits in any event. And so your anticipation was live testimony that can be accommodated for certain. And Ms. Montague, is that how do you feel about that approach then, where we would have pre-filed exhibits with oral live testimony?
I think that's fine. That's fine.
Okay. Then there were some items that were referenced as not being available and would be filed at a later time. Mr. Carson, are those exhibits like ready to go? Could we start with filing exhibits, say, in 2 weeks, 4 weeks? Do we know when that timeline is?
I would have to check with my client to see where I think there was some plans or something that we were waiting on that we asked for preliminary approval on. And so I'm not sure where those are at, Your Honor, but I think we could I could let the court know. I can find out and let the court know.
All right. So then what I'm anticipating will, uh, and then Ms. Montague, you don't have those exhibits, of course, yet, and may not know any more the availability of them. But I would contemplate maybe a 30-day period after filing of CDOT's exhibits for the railroad exhibits. Is that reasonable sounding?
It should be. Let me just tell you the scenario that I am working with, and that is the decision maker, primary witness, I would say for BNSF is about to be on FMLA leave for the month of May. And so that does hamstring my ability a little bit to well, it certainly was a complication in discussing how soon we could have a hearing, right? Because I knew there was at least a full month, and then even if you schedule it right at the beginning of June, that doesn't accommodate me being able to get everything from that person. So I think I'm trying to think about how to deal with that. If we're doing it basically any deadline that I have in the month of May is going to be difficult. And again, just given the person's role and the direct involvement in related to the crossing, that's kind of the issue. It's like, yeah, there is a backup person, but that backup person isn't actually a witness as to some of the things that we wanted to talk about.
Okay. Well, what I'll try to do, I mean, we'll obviously try to accommodate that as we can. I guess what I'm thinking in my head, especially in light of that comment, and Mr. Carson, I'll plant this as a seed. I'll wait for some feedback on the availability of exhibits, but I'm thinking maybe then we have the CDOT exhibits due at the end of May, and then have the railroad due at the end of June, and we could look at maybe a mid to late July, August hearing time frame. Is that subject to change?
Yeah, I've got dates cleared today through July, but I don't have any August dates from the parties. The other question I have, and is, Your Honors, I'm not quite sure what all is going to be contested at the hearing. I know that they've requested some safety signals put in, lights for pedestrians, and I think that's the only real issue, because the other part is just connecting to a cabinet that's on the signals on 119 to the cabinet that's on the BNSF property. But nothing's being proposed at the actual tracks or the crossing. So that'll help in figuring out what we need.
Okay, I
Yeah.
kind of anticipated getting into this a little bit, and it makes sense to do it now. Ms. Montague, the intervention was, I guess, perhaps vague, referencing safety devices addressed during a diagnostic that are not appearing in the application based on your review at the time of your intervention. Can you give us some insight into what the contested issues in the case are?
Sure. So Mr. Carson is correct. The crossing, the work being done for the operation of the crossing as a whole is not being contested. The intervention was done for the purpose of installing a flashing light that is a visible warning, because this is a quiet zone crossing, and the visible light is requested by BNSF as a visible warning to pedestrians and others who are hearing impaired. So who are using the crossing, not in a vehicle. So there is a pathway and pedestrian access, and in fact increased pedestrian access to the crossing once the other improvements that are done, not by BNSF, or CDOT for that matter, once those things are completed in that area, they're going to be higher risks for pedestrians. So the diagnostic discussed, it was discussed that BNSF was requesting a flashing light. There are MUTCD rules that suggest that within a certain distance from a crossing and certain parameters being met, a flashing light is not required per se. So upon leaving the diagnostic, the PUC staff discussed with the someone from the road authority or perhaps with CDOT, such that PUC staff was not going to require the flashing light. This was not discussed with BNSF. It was post diagnostic. So when the application was presented without the flashing light, the request was made, can we add this flashing light? And upon several discussions that have been had since the application was filed and the intervention was filed, the dispute boils down to, at this point, BNSF wants the flashing light, excuse me, and thinks it should be part of the project as a whole. CDOT and the road authority, which is Boulder County, don't oppose the light. In our informal discussions, that was what was shared with me. They don't oppose it, but they don't want to pay for it. So really what we're boiling this down to is the work that CDOT's going to do needs to be approved. BNSF wants to have the light added to the crossing for the benefit of the users of this crossing in a quiet zone. And there's essentially it's a dispute over who's going to pay for it.
Okay. Are there existing sidewalks?
It is limited. The dispute as a whole is fairly limited, I would say.
Okay. Then in terms of, well, excuse me, I was going to ask first, are there sidewalks at the crossing now? I'm not familiar with it.
There currently, as my understanding, Your Honor, is there's currently sidewalks that exist now and they previously existed. There's nothing being done there except for connecting the new signals on 119 to this box that's on 63rd. That's the only thing. That's the extent of the project and the railroad right away. The rest of it's out on 119.
Well, then, as to the for planning hearing purposes, I might suggest the parties consider stipulating to some exhibits and perhaps even facts that could narrow the more formally narrow the scope of the dispute for hearing. Otherwise, we'll go as I proceeded earlier, but that's something the parties sure could explore that might save some fees and costs for everybody in time and hearing. Okay, so I think we do have a better idea of what the case is about. Sounds like, as addressed, it's not going to be a broad dispute, and so I think that subject to change as we find out more information for the availability of exhibits. Tentatively, I'm thinking that we could. I'm going to pull up my schedule. We could well go ahead and set a hearing date at near maybe the last week of July or something along that. I'm just going to see what things look like. Like July 25th. Absent alternate would be 29th or 30th. How do those dates look?
Your Honor, I apologize, and I don't know if there was no availability on those dates, but my list ends at the 24th of July, so I'd have to double check my witnesses, unfortunately. I think that means they're
Okay.
not available the rest of July, but that's where it cuts off.
Um, we could also do the 22nd and 23rd.
And those I
That-
show that none of them were available on those two dates.
Okay. Backing up then the week before.
The week before that, I've got the 16th and 18th. And Stephanie, I don't know what your view is, but I don't know that we'd need more than a day for this.
I think a day is sufficient.
Yeah.
That's where I was aiming. So,
Yeah, I think,
Miss
and I
Monica,
think you're right, Your Honor, we'd be able to stipulate to some things to simplify that as well.
okay. How about July 16th or 18th for you?
Either one of those are fine for me.
Okay. Why don't, excuse me, Mr. Carson, were you going to add to that?
Nope, those are the dates that I gave you that work for myself and our parties.
Okay. And my advisor's available. I'm available. So why don't we go with July 18th?
Okay.
And so we'll have the hearing date set. When do you think, Mr. Carson, you'll have a handle on your timeline for exhibits?
Well, Your Honor, I'm not quite sure what we'll do. It kind of depends on what we stipulate to. As to what exhibits I'm going to need to present. So, you know what I
Okay.
mean? I want to present a whole bunch of exhibits that are not going to be necessary because we've stipulated to it.
Right. That's reasonable. Well, what I'll do then, instead of making 30-day cycles on exhibits, but we do have the unavailability of Ms. Montague's witness coming up in May.
Would it make sense, Stephanie? Would you mind taking a first shot at what you guys would be willing to stipulate to as far as the project, and then we can maybe get those filed, and then we can decide when the exhibits are due based on when we get the stipulations filed with the court?
I don't know. I don't know. I'm concerned about the timeline of that because in other words, I couldn't do that this week. And if my witness isn't available beginning next week, then I've committed to something I can't fulfill.
Right.
So I think, I mean, my preference would be, that I guess what I'm wondering is, can't we do a CDOT exhibit deadline by the end of May? And then at that point, I can expect to be able to confer with anybody about what of those we're able to stipulate to, or I guess, Greg, you're concerned about putting in the work to make those all final and ready if we're still stipulating to them, we have to prepare them anyway.
Right. Well, my thought was we may not, it sounds like we really only need whatever exhibits we need to contest the need for the signal, and not what's actually the work that's going to be done at the bungalow and the lights out on 119.
Well,
And
don't you still have to submit that for approval? If maybe I'm mistaken, but Your Honor, does the actual content of the application still have to be approved? So even if we stipulate to it, it still has to be submitted
It
for
has to be in-
approval.
Yeah, let me jump in here because it does have, it will have to be, the plans and specifications will have to be in the record to be preliminarily approved by the commission. So that is a timing. I guess the other possibility that's come into my mind, if, and this is to CDOT for timing, Mr. Carson, is, we could maybe, as you mentioned, you don't have calendars available for August. We could back up all of this about a month's time. And give some time for the parties to confer after the witnesses return from FMLA. I throw that out as a possibility. I think those are the alternatives. Either we buy more time on the front end for the parties to confer for a stipulation, or we go ahead and have CDOT present their direct case, and then any narrowing of the dispute could happen by stipulation after, based upon the direct case.
It's like everything, Your Honor. This is a project that CDOT really needs to keep moving and get done. So without talking to my client, I'm apprehensive to move it to possibly the end of August.
Okay.
But
well, yeah. Oh, I'm sorry. Go ahead.
No, I do think there's some benefit to having a little more time. It's just my problem is we haven't contemplated out past the end of July yet.
Okay.
And so
well, here's how I'm planning to proceed.
Okay.
I think for what we know right now, that would be that CDOT would present its direct case, and that would basically happen by the time the witness is available. And then I'll set a deadline for BNSF's exhibits and invite and welcome at any time, as the commission always does, for the parties to narrow the dispute through the stipulation or settlement or compromise or whatever you may come to. And then we will hold the July 18 date for hearing. And I remain available if the parties wanted to confer for another pre-hearing conference, or if there was an agreement to modify the procedural schedule, we could look at that. So that would still leave the first deadline being CDOT's exhibits about 6 weeks out. And during that time, you might we've protected the July 18th hearing date that way. And if over the next month the parties agree to do something different, you can let me know and we could reconsider.
Okay. Can I ask one other question, Your Honor? And that is, when you say present our case, we're talking just about exhibits, right? Because we've decided
Yes.
to do
Yes. Just the hearing exhibits for your direct case.
Sure.
Yeah, and Your Honor, I think that sounds workable from my perspective. I'm willing to do whatever I can to both communicate and pass along information that I might receive from Mr. Carson. It's just, I can't say with certainty that I will have the right, the right person to make decisions about what's in that material. So I want to be as accommodating as possible and not have things take longer than they should. The July date sounds acceptable, because I think it does give us enough time to receive what CDOT wants to present and decide from there what we can stipulate to and or what additional we would want to present. So it makes sense to me. That's BNSF's position.
Okay, I'm going to ask the parties if we could just take a brief moment off the record. I'll be here. I'm just going to mute for a moment and be right back with you. Okay, thank you for your patience. We'll go back on the record. I just wanted to confer with my advisor before winding up my part of this. And I believe it's a bit fluid, but I'm happy to proceed in the manner we're talking about today. I will probably issue the decision setting the hearing date, and maybe I'll probably go ahead and put a procedural schedule out there that we can, so we have something to work from based on the timeline I mentioned today that CDOT exhibits end of May and BNSF end of June. And then, like I say, happy to work with the parties if there's need to do so. And we'll be using the box.com process that we've been using for the electronic exhibits. And I'll be including an attachment in the procedural order that describes that process. If the parties have questions or want to do a practice session, we can do a practice session. We can also it also gives the name of those that help us make this magic happen in the hearing, so they will be available as a resource as well. Is there anything further we need to address today?
Not that I can think of, Your Honor.
Not from BNSF.
Okay. Well, I thank you for joining me today. Glad to get caught up in the case, and we'll look forward to hearing from you if anything progresses, and otherwise we'll get a procedural schedule adopted and go from there.
Thank you.
With that, I wish you all a good day and thank you very much.
Thank you.
We're in recess. Bye-bye.